My name is Michael Busby. I am a family law attorney who primarily practices in Harris and Fort Bend County, Texas. When you dissolve a marriage, claims can be made for fraud and waste, and then also breach of fiduciary duty that one spouse would owe another spouse. I generally start with a definition of community property to give an overall understanding of the property concepts and the offsets that can be made based on an unfair disposition. Thus, community property is property owned during the marriage that is received during the marriage. Separate properties, property owned prior to the marriage or received during the marriage by gift, devise, or descent. Everything is presumed to be community property upon dissolution and must be traced by clear and convincing evidence to show that it's separate property. Examples of separate property would be a house owned prior to the marriage. Now, the income off of a house which you own prior to the marriage that you perhaps rented out would be considered community property. An exception to this would be if you have oil and gas royalties that is a depreciating asset. As the corpus depreciates, then that is considered separate property. At the same time, if you are in some type of accident and you have a tort claim against someone, tort claims for pain and suffering are considered separate property, but to the extent that they are for lost income and wages, that is considered community property and can be partitioned upon a divorce. Many times at the end of the marriage, there are transactions that take place because one spouse is cheating or one spouse is hiding assets. There's three general characterizations that you look at in bringing the causes of action. One is the fiduciary duty that each party would have towards each other. And therefore, as you have a fiduciary duty, you must, for large purchases, for major transactions, consult and confer with your spouse. Then you have two types of fraud: actual fraud and constructive fraud. Constructive fraud may be the spouse who goes to Louisiana and gambles frequently versus the spouse who stays at home and goes to church every Wednesday and Sunday and ties very little to the church, but otherwise is a low maintenance spouse. And when you have a spouse with certain types of vices, then that is something that the court can look at as far as the unfair disposition of monies that were spent on those vices. Actual fraud is the transferring of property, the depletion of an account, and the transferring it perhaps overseas to another family member, or moving properties, transferring titles of properties to other members of the family and saying that you sold it for less than fair market value. And then finally we have waste. Waste and constructive fraud are similar, and they are many times used interchangeably. With the waste claim, this is best characterized as the lover of the husband and those dinners, those vacations, those hotel rooms that are being paid for by the husband. For the most part, with women, it's going to be monies that are sent to her family, perhaps overseas. I had a Chinese couple one time where the husband was from mainland China and the wife was from Taiwan, and the wife had sent $200,000 to buy her family a house in Taiwan, for which the husband did not consent. But the husband had a son from a previous marriage for which he paid that son an allowance every month while that son was in college, for which the wife did not approve. So each party had offsetting waste claims against the other. Of course, the husband had the lesser claim because he had spent approximately $36,000 on his son, and then the wife had spent well over $200,000 she had sent overseas. So in the dissolution context, the remedy at the end of the marriage, when you have a waste claim, a fraud claim, is to reconstitute the estate. So for the most part, you need to trace these items out and you need to show specifically where the transactions took place. There is one case which I've cited in the PowerPoint that says otherwise, which is the Peterson case, where the husband, if you were to read the opinion, had earned approximately $200,000 a year for several years, and the wife said, "Where's the money?" And many times people will say, "Well, if you make that much money, you have a certain lifestyle," and it was probably spent on clothing and the mortgage. But with that particular judge, who is now retired, she was very matriarchal and definitely a narcissist female. Yeah, she was of the opinion that you need to trace it all out, and all you need to do is make an accusation. And I've represented women in there, and the accusation's been made, which is very similar. Someone who owned a business, and they had $300,000 from a son that had passed away, and they received it through a tort claim, and they had invested in a bakery, and the bakery income and expenses were approximately $30,000 a month, and over 5 years the $300,000 had been spent down, but she still came after the wife very hard, because the wife controlled all the assets, and there was a disproportionate share given to husband, but that was also because the wife had transferred some properties around, and there was some other evidence that did not favor her. But that is unusual, and as I've said, that judge is now retired in Harris County, but that case is out there, which is persuasive and binding in this region until it's otherwise. You have a new case that comes up which overrules that case. So for the most part, my advice would be to trace out any waste claims, and if you cannot trace it out, then your fallback position would be the Peterson case. Again, my name is Michael Busby, and you can reach me at 281 Divorce.